I hope Tony's back as well. I'm going to just introduce, I'm not going to introduce, obviously, Tony Topman. We just heard Tony give us an overview of the TRIPS, and it was a fascinating conversation on compulsory licensing. So, and there are some questions in the chat that we will address to all of you. Joining us today is also Simon Evenett. As always, all the bios are on Canvas, so I will do a brief introduction. He's Professor of International Trade and Economic Development at the University of St. Gallen and the founder of the St. Gallen Endowment, the new home of the Global Trade Alert Initiative, the leading independent trade policy monitoring initiative. Professor Evenett was the first director of economic research at the World Trade Institute and has been the co-director of the CEPR's International Trade and Regional Economics Program, the leading European-based group of researchers in international trade and economic geography. Next, we have Dr. Henning Grosse Ruse-Khan, who is a university reader in international and European intellectual property law at the Faculty of Law of University of Cambridge. He's a fellow of King's College in Cambridge. Dr. Henning is co-director of the Center for Intellectual Property and Information Law and a fellow at the Lauterbach Center for International Law. He also holds position at Max Planck Institute for Innovation and Competition in Germany and the Center for International Sustainable Development. I want to also, he was also in development law in McGill. In 2020, Dr. Henning was appointed as fellow at the Weizenbaum Institute for a Network Society. Last but not least is my dear colleague, Sean Flynn, here at American University Washington College of Law. He's the director of the Program on Information Justice and Intellectual Property, where he teaches us course on the intersection of intellectual property, trade law, and human rights. He's also the editor-in-chief of InfoJustice.org and the chair of the Global Experts Network on Copyright User Rights. For more detail about his accomplishment and others, please look up on Canvas. I'm going to hand over to Renata, who will be moderating this session. Thank you all.
Thank you, Paddy. Thank you all. I believe this is one of the most awaited sessions of our program. So thank you very much. I hope you all enjoy and ask a lot of questions, because if you don't get answers here about this topic, I don't know where you're gonna find them. So the COVID pandemic represents an unprecedented disruption to the global economy and world trade, as production and consumption are scaled back across the globe. Maybe the current challenges affords an excellent opportunity to demonstrate the central role of trade and international cooperation in addressing the world's most pressing problems. Among the great initiatives that are happening, for example, among international organizations, I would like to highlight the first virtual course on trade and public health that the WTO, together with the World Health Organization and the World Intellectual Property Organization, are running right now. So without further ado, I would like to start the first question and address this to Simon Evenett, because Simon has been, since the beginning of the pandemic, following countries resort to various forms of protectionism as part of national policies, policy response to the coronavirus. So Simon, how is this scenario shaping the world supply chain, and what to expect considering the new variants of COVID-19? Simon.
So thank you very much for the opportunity to speak in this program. I think to answer your question, I need to build the argument up and provide some context. Many of the medical goods, medical equipment, and vaccines that have become used during the pandemic are manufactured and delivered through very extensive cross-border supply chains. It's important to recognize that those supply chains differ in terms of complexity and alike. Some are much more complex, some are much more intricate than others. Nevertheless, the idea that a product crosses several borders before it's being delivered to a customer is central to the notion of a supply chain. Now, when the pandemic hit, there was, and remember, it hit different countries at different points in time. In the countries where it hit, there was a surge in demand typically for medical items. And this surge in demand, of course, put pressure on companies in supply chains to deliver. And it's at that point that we began to see policy change. Now, so much of the attention in the newspapers and the policy debate is on export curbs. But I think a balanced approach requires acknowledgement of the fact that by the second quarter of last year, there were over 200 different moves by governments to liberalize trade in medical goods and medical items. Some governments realized that it was absolutely nuts to have import taxes on soap. And in fact, there were literally dozens of governments, actually over 100 governments, had import tariffs on soap, and nearly 80 had import tariffs on soap, which were in excess of 15%. So this is an example of how governments responded to the crisis in a way that was actually supportive of international trade. And when people make the argument that trade helped in the pandemic fight, we should acknowledge that. And I believe Tony already made the argument that the production of various key medical items scaled up dramatically last year and helped narrow those surpluses. So that's the sort of positive side of the story that we observed in the data. We also saw, of course, resort to export curbs of different types that governments used. Some were formal export bans, some required export authorization, some were informal bans, some were involved leaning on companies not to export. But nevertheless, we did see a surge in the second quarter of last year in the number of export curbs. So, in fact, I think the maximum number we documented in any 1 week being in effect was 138. That number is now fallen down to about 80, suggesting that there's still some medium-term scarring as far as this, that type of policy intervention was concerned. Now, the impact of these export curbs was very quickly felt, and in fact disrupted the supply chains. And here, notice that the disruption to the supply chain came from public policy. And now these, I am not a lawyer, so I'm going to let the lawyers talk about whether this stuff is allowed under WTO law. By and large, it seems it is. So governments used whatever flexibilities they thought they had and tried to prevent goods being exported, medical items being exported. What they, I think, very quickly realized was that other countries could follow suit and that the disruption ultimately can reduce the total amount of supply across the world markets temporarily, and this didn't serve anyone's purposes. And for that reason, a large number of these export curbs were withdrawn relatively quickly. They were a very ineffective policy instrument. Now, it's not hard to understand why. Go back to what I said earlier, we had a pandemic, a surge in demand for items. What matters is getting supply up to meet the demand or getting demand down. And this demand increase is a function of the quality of the public policy response of countries. Did they lock down too late? If they did, they probably faced a higher level of demand than they would have done if they'd locked down earlier. Some countries or some jurisdictions like Taiwan introduced a rationing, for example, for masks. And limiting the number of masks per individual. Other countries chose not to do that, and that may well have led to higher levels of demand. So when we think about the shortages which arose, please don't blame them all on supply chains. Actually, a shortage is a function of the demand surge as well as the supply response, and the demand surge was a function largely of public health policies and, quite frankly, mistaken public health policies. Once governments realized they'd screwed up their public health policies, then the health officials' instinctive response was to try and grab as much local production and restrict supply. This then triggered the supply chain disruption that occurred. And quite frankly, my interpretation of this is there's a lot of health officials who are on a very steep learning curve about the realities of supply chains in the sector that they should have known about. So these policies, I think, were largely counterproductive and were unwound. I would make one other important point here, which is that there were some big jurisdictions which did not invoke export curbs. We found no record that Japan did, that Canada did, and we found no record that Australia did for its domestic exporters. If you wanted to buy up loads of masks on Australia and ship them somewhere else, then they banned that, but not for their own domestic exporters meeting orders abroad. So it does beg the question if 3 G20 members like this can go through a pandemic and fight a pandemic effectively without resorting to export curbs, why can't other WTO members as well? So you can see here that on net, I'm a little bit skeptical that these the public policy responses were, at least as far as the trade policy responses were concerned, were particularly effective. Now, when we come to vaccines, and I'll say a little bit about that before stopping, vaccines, of course, are produced in elaborate cross-border supply chains too. And it's very important to realize that there are different types of vaccines which we have. They probably have quite different supply chains. One of the things we found in research with colleagues is that there's a small number of countries that produce final vaccines and a very small number of countries that produce ingredients. And by and large, there's a large overlap between those two groups. So think of it as a vaccine production club, where the producers of final vaccines are often the producers of the ingredients to vaccines. This creates a very interesting dynamic, because it does not make sense if you're an exporter of final vaccines to publicly ban the exports of these things, because you will invite retaliation from the exporters of ingredients of vaccines. And for this reason, many of the export curbs which have been put in place on vaccines have often been below the radar screen and embedded in other public policy instruments, maybe linked to public procurement and the like. So we've had a lot more murkier protectionism or export curbs in the context of vaccines. And so the dynamic there is different, largely because of this, the industrial organization in this sector having a lot of the ingredients producers being the final goods producers too. Now, of course, if you're outside of the vaccine production club, that is, you're neither a producer of a key ingredient or the final vaccines, then you have much less leverage, and this puts your country at a considerable disadvantage. And I'm sure we'll get into this when we talk more about the TRIPS waiver and the like. And there's a very important question about the distribution of vaccines, not just the production of vaccines. And I think that's a distinction which should not get lost as well. So as far as the vaccine production, vaccine supply chains are concerned, they differ from the medical goods we saw last year, largely because production is so concentrated. One last observation, and then I'll close. There's a lot of people worrying about shortages in vaccine ingredients and alike. And what I would say there is that a number of people have articulated those concerns. You can certainly point to statements by some corporate executives, but it does not seem that these vaccine ingredient shortages has stopped the impressive ramping up of production of vaccines that we're seeing. So not this week, last week, we saw over 200 million doses produced. The week before we saw that. If you go back to the month before, the production levels were 100 to 150 million doses a week. So we're seeing a very aggressive production ramp up, and this has not yet been constrained by vaccine ingredients shortages, despite what some people in the private sector have said. So I'm cautiously optimistic here. There are, of course, if you look at the projections for vaccine production throughout the rest of the year, in the Q4 is when we're expecting to see massive increases in the amount produced, literally because a number of vaccines are likely to production is likely to come on stream. If there's a vaccine ingredient shortage, it will show up probably then, not before, because between now and the end of Q3, the additional production per week is pretty much in line with what has been produced in the last month or so. So if we can sustain this level of production without running into shortages, then I think we'll do very well. And of course, if we get through to the end of Q3 with the current levels of production, we will go a hell of a long way towards producing the vaccines needed to inoculate the adults of the world. What we have in Q4 is very important to get done. But I really want to emphasize that the production scale up has been incredibly impressive, and the people who track that production scale up are forecasting increases which seem to be, I mean, their forecasts are remarkably accurate, certainly more accurate than either weather forecasting or economic forecasting in general. So I think we should not over exaggerate the fear of vaccine shortages and vaccine ingredient shortages, and actually focus much more of the conversation on the distribution of the large number of vaccines that are being produced. Let me stop there.
Fantastic overview. Thank you so much, Simon, for kicking off our debate. I'd like to invite also the other panelists, if you want to jump in, please do so. And also, like before I ask a question to Anthony Taubman, I need to say that although I'm a lawyer, I'm fascinated by the platform that Simon runs, Global Trade Alert, and most of the numbers he mentioned are there. It's very interactive, so I always make a propaganda for your platform, Simon, so thank you so much. Sean, would you like to comment?
Yeah, let me jump in a little. I thought you know, Simon's intervention there was a really useful and excellent starting point for this discussion about trade on the one side and then access to some particularly important goods on the other. And it was useful because I think that's in some respects, Simon, that was, correct me if I'm wrong, but what I hear from that frame a little bit is more the traditional trade story, which is that you know, overall exertions of kind of sovereign interest, local interest, thinking too much about your own country rather than others is potentially the problem, and is going to, you know, muck up the supply chains and make us all worse off, which to some extent is the justification for the WTO, right? I mean, the WTO tries to address these kind of barriers so that exertion of local interest doesn't hamper the general global interest, right? And so on that side of the story, that's kind of weaving it out. I mean, I don't know if you want to, you carefully avoided the question. I don't know if you want to address it. Like, do you think, you said there were several kind of, I don't know if you said protectionist, but you could say there were kind of protectionist local policies that seem misguided. Do you think the WTO should have the capacity to oversee those? You know, whether you kind of avoided whether those are legal or not, but let's bracket those, because I think it's the question of the day. Should the WTO be able to adjudicate those kind of exertions? So export bans, for instance, you know, that clearly affects global public health, but is exerted because of you know, an assertion of local public health. Should that be, do you think that should be potentially adjudicated through the WTO system?
So if I can respond to that, let me answer that in two parts. So the first is, if the question was, do I believe that it would be useful to have WTO disciplines which members agreed to restrain their use of export curbs? The answer is absolutely yes. And I think there's a number of very good reasons for that, not just the disruption of the supply chains, but think about the interests of an importing firm from importing country in medical goods. They will only be prepared to liberalize their tariffs on imports if they are assured supply, and if they believe that the foreign supply is going to be cut off in a crisis because of export curbs, then the importing country may be more unwilling to liberalize in the first place. So even for exporters of these goods, countries that export, they actually have a strong incentive, in my view, to tie their hands. To date, governments have been reluctant to take on those obligations, and there's been big pushback against suggestions that they do, which I think is a mistake. Now, if we and let me say that if we did have these obligations, now I'm going to say something slightly different. If you think about how these crises unfold, Sean, we have a pandemic, a country puts in place an export curve. You know, even if we had an appellate body at the WTO which was working effectively, it would take 9 to 18 months, probably 18 months, to get a ruling, by which time, you know, the damage has already been done. So I think the only way to make that type of discipline on export curbs really work is if there was an expedited procedure whereby governments were brought to book very quickly and encouraged to remove those measures. So I think the solution then is not just stronger WTO disciplines, which, footnote, I see governments having no appetite for. It's also a different type of dispute resolution procedure, which you would have to back it up with.
Excellent. Henning?
Yeah, just on this particular point, I think it's interesting what Simon was just referring to, not only in terms of the dispute settlement mechanisms, but if you think, or if you compare it to the mechanisms you have in the European Union and possibly in other regional integration systems. You have the Commission as a guardian of the treaty who can in itself take action. And of course, we don't have that in the WTO for good reasons, because countries weren't willing to cede sovereignty to such an extent. It's probably not likely that we will have it anytime soon, but this situation shows how good it would be if we did have it, because we have markets to an extent which are integrated globally, and we have global needs, but we don't have the legal tools to address one-sided individual country protectionist policies. Just as a brief point. Thanks.
Excellent. Anthony, I would like to give you the chance to expand a little bit some of the explanations you started during the session. So for the past few months, we have seen the WTO at the center of the pandemic-related discussions. One of the main topics on the table is the IP rights issue, the recent US position in favor of a patent waiver for vaccines, the India and South Africa broader waiver proposal, and different approaches being eventually discussed by other members. Could you share with us what is the current status of the discussion, the differences between the proposals, and why is it important? You're muted, Anthony.
I think I would have learned 18 months into this pandemic, sorry. So thank you very much, Renata, and thanks for the chance to join this really impressive colleagues on this panel. Because I'm sitting in my office now, I have to tread carefully because this is a matter that divides WTO members, and the Secretariat is not called on to take sides. So if I do stray too far, I hope you did put my CV on the website, because I might be looking for a job. Anyway, but I'll do my best. So
we'll take you, Tom.
In a nutshell, Simon has covered the broader, if you like, mainstream trade policy questions that have come up. And I would add to that, apart from the enforcement question, which, of course, as lawyers, we're really into, but the transparency and political commitments and a degree of peer pressure, I mean, these are not insignificant matters. And it is increasingly becoming clear that there's a common resolve, especially to address vaccine equity, and above all, a recognition finally that vaccine nationalism is self-defeating. I quoted earlier the WHO Constitution that includes a reference to health problems in one country are a concern to all countries. That's not utopian. That's, if you like, grittily pragmatic, realistic. And we see this, of course, every day. And the escape of variants is a reminder of this. So when it comes to the IP matters, there is I think a common resolve across the membership that we can't rely on business as usual. There's no point saying that the day-to-day innovation and access mechanism, the IP dimension of that is going to be enough, is going to be sufficient, is going to be allow timely action. The spectrum of views, and I put it that way, really relates to the best instrument for achieving that outcome. And in particular, just how much the intellectual property system is getting in the way. So we have a proposal that the one that has attracted most attention and most activity, diplomatic activity here, is a waiver proposal initially put forward by India and South Africa, but co-sponsored now by a wide spectrum of developing countries. I want to make clear two very specific points about this. It's often described as an IP waiver, sometimes as a patent waiver. It's not. There's no such thing at the international level in the WTO. It is a waiver, a proposed waiver of obligations under the TRIPS agreement, our agreement on intellectual property. The TRIPS agreement is not IP legislation, it's not patent legislation. It's a set of principles that our members have agreed to apply in their domestic systems. And they have a wide range of freedom or flexibility to take up those principles and apply them in different ways as they have in their domestic systems. So what is proposed initially by India and South Africa is a waiver of certain TRIPS obligations at the treaty level that affect domestic or help shape domestic IP systems, but it is not an IP waiver. It's not a patent waiver. So should there be a diplomatic breakthrough and an agreement on a TRIPS waiver tomorrow, unlikely, if that were to happen tomorrow, the effect in domestic systems, and we'll talk about this later, would be nothing. There would not be a sudden cascade of you know, if you like, open source vaccines available. Countries would have to take specific steps if they wanted to waive IP rights, and I think we'll be covering that subsequently. That is important because I think there is a misunderstanding that this is somehow the WTO waving a hand and dispensing with IP protection. It can't do that. It doesn't have the authority to do that. It's a mixing of categories between international and domestic. So what India and South Africa have and co-sponsors have proposed and recently submitted a revised proposal, it is a waiver. There's a specific provision in our treaty, which is the WTO treaty, the overarching treaty that governs, that brings into force all the subsidiary agreements, including TRIPS, which is an annex. It's not a standalone treaty. There is provision in that for a waiver of obligations in this legal system. That has a specific diplomatic process. When it concerns the TRIPS agreement, it has to go to the TRIPS Council, which is the subsidiary body dealing with intellectual property. That then passes a recommendation to the General Council, which is the higher level, and that General Council can then adopt a waiver, which relieves members, countries, of whatever the obligations are. South Africa and India and co-sponsors have proposed, it's fair to say, quite a wide-ranging waiver. It covers TRIPS provisions for all WTO members, and it covers the areas of copyright protection, industrial designs, patents, trade secrets, and clinical trial data protection, and in a wide range of technologies relating to the response to the COVID pandemic. So should there be agreement on this and should it come into effect, then countries, members of the WTO, would have a wide range of options to reduce, suspend, somehow limit the effect of intellectual property systems in their domestic systems. There is one other proposal in the TRIPS area, which has been tabled by and introduced very recently, last week, by the EU. And that is, I might say, more, shall we say, more traditional in character. It works within the existing legal framework and seeks to clarify it and perhaps streamline its application in the area that we discussed earlier, the area of so-called compulsory licensing. And as I discussed earlier, compulsory licensing itself has to be seen as a range of potential tools. It corresponds to the fact that this is focused on patents now, not the other areas of IP, which is a very specific limit compared to the waiver proposal. In the patent area, there's a range of ways of overriding the exclusive rights that come with a patent in the public interest, ranging from a compulsory license to redress anti-competitive behavior, through to the government simply saying, look, we are the government, great patent, great technology. It turns out there's a pandemic on, so we're just authorizing someone else to produce the vaccine. You can seek compensation if you like. So there's a wide range of possibilities there. The EU proposal takes up several technical aspects of that, and I think seeks to clarify those, respond to areas where other governments have said, look, we think this system is too unwieldy to use in a pandemic. The EU approach is to say, well, look, we can look at that and maybe loosen up some of those difficulties, overcome some of those obstacles through greater clarity of the system. But these two proposals are, in formal terms, if you like, on different diplomatic tracks. As I've mentioned, a waiver proposal has a distinct pathway outside even the TRIPS agreement. It's part of the overarching WTO agreement, Article 9, and that has its own kind of diplomatic pathway. At the same time, the EU is proposing what would be, I think, a declaratory clarification, similar in character, I think, to the Doha Declaration on TRIPS Agreement of Public Health from nearly 20 years ago, which, footnote, I think still remains very pertinent and useful in the context of the pandemic. But clearly our members, certainly not all of them, view this as insufficient, and a pandemic requires more. You've mentioned the US position. The US has stressed a preference, I think, for, well, again, it's not a patent waiver, but a TRIPS-related waiver of TRIPS obligations, and the US has, I think, in its statements, emphasised a focus on vaccines, whereas the proponents of the overarching waiver itself have said, look, a wide range of technologies should be involved, including therapeutics, including medical devices, ventilators, protective masks, and so on, diagnostics, because the response to the pandemic has to be more than just the vaccines. That said, most recently, of course, a good part of the debate has concentrated on vaccines, because that's where I think everyone sees a direct nexus between effective distribution, overcoming inequities, and as Simon's mentioned, greatly ramping up production and public health outcomes, and it's very direct. But recently the debate has turned to the other areas, because people are looking to, if you like, a persistent situation with COVID where there are variants, and diagnostics and therapeutics will be just as important in containing the impact of the virus. I think that's covered the main architecture of the situation. Obviously, there's a huge amount of nuance, and there's been a very complex debate. One thing I would say the debate is not about, or shouldn't be about, although it has come up, it's really not a show of hands as to whether you think the IP system is great for innovation or not, because there is already hardwired in the system very significant, and voluntary licensing especially, the idea that it will just have lots of voluntary licensing and it'll be okay. The debate is not about that, because, as I've mentioned, the TRIPS agreement and the existing provisions do allow for the public interest to override the wishes of the IP holders. That's unambiguous. It's sometimes misunderstood. That's really unfortunate, because it's very, very clear. However, the debate is whether those existing flexibilities, even if used in a more effective, coordinated, aggressive way, whether that's really enough to deal with the pandemic. That to me is the nub of the issue. Do you take the existing toolkit and push it to the limit, or do you need to augment that toolkit? That to me is the essence of the IP debate.
Excellent. Thank you so much, Anthony. Comments? Sure.
Jump in again. Yeah. So that was really excellent. Thank you, Tony. And I think so. I wanted to chime in and kind of re-emphasize and point out, especially for the trade law students, right, that the shift that just took place, and that trade debates tend to be about the degree to which we want an international structure of rules to be able to intervene and cabin local decision-making based on parochial interests, right? And so the first discussion that Simon was raising about why WTO rules may be really important in order to meet the demands of vaccines and make sure that supplies are available for everyone, et cetera. But the TRIPS waiver has shifted that discussion. And as Tony mentioned, pretty much everyone, even the ones that are opposed to the TRIPS waiver, kind of agree that all countries need to have the ability to override intellectual property covered by WTO agreements in this situation. That every country should have the flexibility to issue what you call, compulsory licenses, which you mentioned, in order to either import or make their own vaccines. And there seems to be a consensus on that. Even the European Union, which is the one that appears to be blocking. And so, if Tony won't say it, I will. There's not going to be a TRIPS waiver tomorrow, from what I hear. So the EU is still blocking the TRIPS waiver as of today. But even the EU is saying, yeah, but we're totally happy to have an instrument which makes it very clear that everyone can use a compulsory license if they want to, even for a parochial interest in this situation. So the interest is the same, public health on both sides, but on the kind of traditional trade matters, there's at least debate whether the open trade system as enforced and envisioned by the WTO is the answer, not the problem. Whereas in intellectual property, there seems to be a growing consensus that not necessarily that TRIPS is the problem, but that IP may be a problem and that countries should have the local power, the sovereignty, to overcome it. So it's that theme that overrides trade between kind of sovereignty. When do we protect it? When do we make sure sovereignty trumps versus kind of interdependence and, the global system, and when should the global system trump? And they seem to be on different levels. Tony, I would love to follow up with a question because you mentioned a very advanced topic that I don't even know the answer to, that, and I've heard this banding around, that the waiver has a different procedural status. It's a separate question. It has its own process under the WTO versus a ministerial declaration, which also has its own status under the WTO. And I did notice that the EU responded to the waiver with a declaration. So how are those being dealt with procedurally? If you could say more.
Well, frankly, it is very sensitive at the moment because, but for a fairly transparent reason, I think, because not every member has agreed that a waiver is the answer.
Sure.
And yet there is a large number have been pushing this, but not every member has, and yet there is both enormous pressure and I think enormous appetite too to work intensively at the same time towards an outcome. It may sound, it is optimistic, but there's some hope for an outcome when the General Council, the next level up, meets at the end of July, end of this month. So it is procedurally difficult because the guy running this is the chair of the TRIPS Council. He's a Norwegian diplomat. His job is to forge consensus, bridge across differences. And at the moment, the approach is to work ahead on the content. But at some point, yeah, you have to work out: am I going to flick the switch on the specific WTO type waiver, Article 9 of the WTO agreement, or is it some other outcome, or is it a combination of the two? There's nothing to stop that procedurally from taking place. But in the end,
can you discuss both of those instruments in the same meetings, or do you have to have separate meetings to discuss those two things because they have a different procedural posture?
Not at the moment, but they're both covered under the our subsidiary body, the TRIPS Council, and in any event, for it to go to the level of ministers, it would go through the General Council anyway. So no, there's nothing to stop the two being dealt with in parallel as they are now. That's there's there's also, I mean, there's also what's on the formal agenda when the council meets formally and so on. But there's a lot of informal negotiations and discussions underway, which the chair is leading. And of course, that can be, you can talk about anything. You can talk about the weather if you want to, but you know, they are, I can say, focusing on these two clusters of work at the moment.
Excellent. Henning, I think I'd like to.
Yeah, thank you. Just to maybe add on that particular question from Sean. So as Tony was pointing out, you have this essentially addressed under Article 9 of the WTO umbrella agreement, where I think Section 1 primarily looks at decisions of the ministerial conference, and Section 3 would specifically address the opportunity for waivers in exceptional circumstances. I don't think anyone would question whether we are or not in exceptional circumstances at the moment. So even if 9.3 might set up a particular additional substantive hurdle, I don't think that would be questioned. But I think the more interesting question, Sean, would be, well, what's the difference in outcomes? I mean, you will remember we have had debates about the legal status of the Doha Declaration, which emanated from a ministerial conference. And there was no question about the status of the decision, which eventually waived Article 31H in relation to the mechanism which is now embedded under Article 31 bis, which allows one country to request a compulsory license to be issued in another country for export purposes. So there we have a waiver in place. That the legal status of that waiver is pretty apparent. It waives the obligation of that particular provision which is being waived, and you don't have to commit to it anymore without there being a breach of the WTO rules. Whereas when you have a Doha type declaration coming from the ministerial conference, which doesn't necessarily need to be, I think, the only type of decision made by a ministerial conference, but if you just had another type of Doha declaration, you might again have debates about its legal status, as we had in the Australian plain packaging cases, where the panel considered it to be a subsequent agreement on the interpretation of the TRIPS agreement. The appellate body desisted from confirming this because it wasn't necessary for the purpose of the analysis of the appellate body. So I think there might be further follow-on question about the legal status if we were going down the route of a ministerial conference decision. But I guess that also would depend on the type of decision and what kind of political will is behind it, and whether anyone would want to actually challenge that. Thanks.
Simon, I see your hand.
I have a question which I hope Tony can answer for us, which is that suppose India and South Africa were to get their way and this TRIPS waiver was granted today. Does that translate then into additional vaccine production, or are there additional steps? For example, would one have to find production facilities, then either build them or repurpose them? Would one then have to secure the ingredients, the scientific talent necessary to produce them, as well as possibly tacit knowledge, which is necessary to manufacture? So what I want to get at really is a TRIPS waiver a necessary or a sufficient condition for increasing production of vaccines?
Right. Easy question. Well, the easy answer is certainly not sufficient. And the proponents themselves have said that very, very clearly. The necessary part is ultimately an empirical question, in my view, and it's not an easy one to answer really in an authoritative way. It will depend on, well, the answer is it depends, of course, typical secretariat roundabout, but the issues are, what is the nature of the patent landscape? Very hard to determine that, particularly for a new technology, as patents are still coming through to publication. Is it one of the is it one of the really novel vaccine platforms, mRNA, which literally had been produced in trial batches of up to 10,000 a year ago, and now is being produced in its billions. A totally new vaccine platform where that kind of tacit knowledge, that kind of human-to-human transmission of know-how may be very important. Even in that area, I mean, Martin Frieder and colleagues in the WHO are pioneering really important work on establishment of mRNA platforms, initially in South Africa. Their initial take is that there's no immediate patent barriers based on the background technology, but it's very difficult to determine that absolutely in terms of freedom to operate. Other more conventional vaccine technologies, it may be easier to reverse engineer or simply replicate those, and that's where the absence of applicable IP rights could be relevant, and then we get into broader areas beyond vaccines, of course, where it ranges everything from industrial design, registrations of masks, through to the software embedded in a ventilator. I mean, there's all sorts of things there. So it becomes very complex then. Yeah, it's not going to trigger an immediate response, and the proponents have said that. They've said that this is part of a background set of tools that need to be on hand when the problems they expect they will encounter when they turn up. So they've explained that's why it is so broad in character, because it's not a band-aid zeroing in on one specific difficulty, but a catch-all in case of issues. The other difficulties, we are talking about technologies that don't exist at the moment, new therapeutics and so on, improvements of diagnostics, and it's difficult to predict, or difficult to even to know the existing patent landscape, let alone the future landscape of emerging technologies. So, I hope I've at least given a sense of the complexity of the issue. Ultimately, it is an empirical matter, but a mixture of understanding of the technology, understanding production capacity, understanding the nature of the technology and the IP landscape. And these are all moving targets in any case. But I think it's fair to say nobody could rule out that there would be specific obstacles in the vaccine area. And as production capacity expands now, we may see those coming into play.
Yeah.
So this jumps our schedule a little bit, Renata, but since it's popped up, I wonder if we can jump right into it. But so, I mean, I agree with everything Tony said, and I think, will a TRIPS waiver immediately solve any kind of production capacity problems? I think the answer is no, but nobody argues that it is. So in some respects, I think it's the wrong question. I think there's a couple different ways to frame what I think is probably the right question. One is not necessarily like, if you're only going to do one thing, what are you going to do? Because we're not going to do just one thing, right? We're going to do lots of things. And so one way to frame the question might be, what would be the most useful thing that you want your trade negotiators to do? So the trade negotiators are not going to solve all the different scientific problems or supply chain problems or everything else. And so when you're sitting there as the head of your country and you're giving your trade negotiator an order about what it should do in the WTO, what's the most useful thing it could do? I'm not necessarily sure a TRIPS waiver is the most useful thing it could do, but I think it answers a different question, which is, might it be helpful and will it harm? And so my answers there would be, might it be helpful? Yes, I think definitely it might be helpful. I think the reason is because the scale of this problem is so much larger than anything else we've encountered. You know, the Doha Declaration around access to AIDS medications, first, hugely successful. At the time that that was passed, less than 1% of Africans in need were being treated with AIDS, and today it's over 70%. And part of that is because we have a massive scale up of generic production over the world. So if you see the kinds of drugs that are being consumed in Africa now for AIDS, most of them are generic, and most of them are being produced, you know, after the Doha Declaration. So distributed production was the answer. But AIDS drugs is a global market of 50 million a year. We need 16 billion doses a year to meet the coronavirus demand. Plus, we're going to need new variants, you know, new doses, new formulations to hit variants. And so the question is, what do we want that global market to look like? Do we want 4 or 5 companies with massive amounts of production, essentially serving the world? And how long will it take to get there? Or do we want lots and lots of different firms in different countries serving different regions, and not only serving those regions to get to the numbers that we want, but also through the process, learning that technology so that they might be able to actually innovate themselves? And so I think that that's a vision, that latter vision of distributed production and distributed innovation that we'll get to faster if we relax some of the IP rules in different places. Now, then the question is, well, but will it hurt? You know, so is that going to hurt global innovation in the sense to which we pay more than we benefit? And so on that, I don't think so. And I think the reason is because IP is giving very minimal incentives in these markets, at least if we're talking just about vaccines. You know, so we think of a blockbuster patented drug as one that makes something like $1 billion a year. And Pfizer has already made over, I believe it's 16 billion, may even be higher than that. And so it's already got 16 blockbusters worth of compensation for innovation. It frankly doesn't need any more incentives. And it honestly didn't need IP incentives in the first place. So what were the incentives that brought the current actors into the market? It was advanced purchase commitments, which is a form of reward that acts like IP, but is not dependent on IP. So governments came out and said, we're going to buy whatever you make, just make it. And we did. We bought drugs, you know, the US bought drugs that it's not even using, so because it had those commitments in advance. So advanced purchase commitment is a very strong pull. And then the other, of course, is direct funding. And the US and other governments directly funded, gave, you know, essentially grants to pharmaceutical companies, et cetera. So there wasn't a strong IP incentive, and that means, you know, fiddling with the IP, I think will have, you know, minimum negative impact. And the potential positive impact is to not only have those same, you know, 4 or 5 firms making the next versions that we distribute the innovation that comes. So I would say, you know, some help and probably not much hurt. So it seems like a good thing to send your trade negotiators to do, but it would be an interesting question about if you ask your trade negotiator to do something else. You know, is there something better that a trade negotiator could do to help solve the problem? And there might be.
Simon, I saw your hand up, and maybe Simon, I would like to add since you're going to speak now, I'd like to add one question too, because I remember a few weeks ago we were talking and you mentioned something about the timing of the waiver, right? Whether does it make sense to you or not? I think it follows up the question you made to Tony. So if you may comment on that.
Right, and I'd like to come back a little bit to what Sean had said, because Sean wasn't sure that my original question made much sense. I think as in a narrow technocratic sense, he might be right, but the purpose of me asking this question was largely to relate to the momentum which is being built by certain analysts, NGOs, and the pressure they're putting on Western governments. I submit that if you went to trade ministers in much of the Western world, or indeed many other countries, and said, actually, a TRIPS waiver is not going to lead to a substantial increase in production in COVID-19 vaccines, those trade ministers would say, what? Because that's not the message they're getting. They're picking up the New York Times and being told that the impediment to expanding production right now is a TRIPS waiver. So I would argue that the political salience of the question that I was asking may be a lot more important than its technocratic salience. So that's the first observation. The second observation has to do with how much, what vaccines do we need and how much are we likely to get? So we've had, and I think it's fairly clear, this, if we want to have 2 jabs for each adult member of the population around the world, we need around 10.8 to 11 billion jabs this year. If we want to have booster jabs, we need more. If we want to inoculate children, we need more. So there's, and these are mathematical questions, right? So this is not, but if we want to inoculate the adult populations first time around, we need 10.8 to 11 billion. And that's exactly the number which conservative forecasts by independent consultants expect us to have at the end of this year, which then comes back to Renata's question, timetables. Suppose we do have a vaccine, a TRIPS waiver for COVID-19 vaccines. Given that most private sector estimates suggest that it takes 6 to 9 months to produce, to get up to speed a safe, regulatory approved vaccine production facility, those facilities would come on board in the first quarter of next year, which could be useful for the booster shots we need, and if we're going to inoculate lots of children. But let's not think that it's going to help much before then. And by then we may well have inoculated 70%, which is the herd immunity level of the adult population. So I think there's a question here, and I think this is, it's not a legal question, and I know the audience is principally lawyers, but one of the important things we have to do as trade policy analysts is overlay our subject knowledge onto the real timetables which face decision makers either in government or in the private sector. And I would submit that there's already a timetable mismatch. So even if this TRIPS waiver were awarded tomorrow or agreed tomorrow, I don't think we're going to see much of an impact of this until the first quarter of next year at the earliest. And I think that that's an assessment one could defend based on independent experts' assessment of what it takes to scale up vaccine production. Let me make one other comment, and it was interesting how Sean built the argument going back to AIDS drugs. And this, I mean, the AIDS drugs episode was, quite frankly, a travesty, and the companies involved have been rightly criticized. But I think it is also an accurate statement to say that the manufacture of an AIDS drug and the ability to be able to replicate and do that with a compulsory license is significantly easier than either of the new 2 types of vaccines which have been put out. And on the mRNA side, we have seen consistent statements by Moderna and Pfizer saying, we just don't have the staff to be able to scale up and help other people do distributed manufacturing. Now you could turn around and say, well, of course they would say this, but then just think about the fact that this is such a new technology. It's not like there are football teams of people out there who can be shipped abroad to help with distributed manufacturing. With respect to the traditional vaccines, look at what happened to the Serum Institute of India. It has a 50-year track record of producing pharmaceuticals. It's supposed to be the leader in producing vaccines in the developing world. And even with the support from AstraZeneca and alike, it has been unable to scale up production according to its initial forecasts. And just so we be clear about this, the CEO of the Serum Institute has gone on record admitting that vaccine ingredient shortages are not the reason. And so what I take from that example and the tragic case of the Serum Institute is that even if a company gets the support from the patent holder to scale up production, there's no guarantee of success either. So all of these considerations make me very, very suspicious that when you add in the practical considerations, going beyond the legal considerations, the timetables just don't match, and that the best shot we have is ensuring that the production scale up of these vaccines is not disturbed. And that's where the discussion going back to export curbs and other trade impediments becomes very important. So forgive me for adding in non-legal considerations, but I think from a public policy point of view, that's exactly what's needed.
I'm sure you'd like to comment, Sean.
Yeah, and I don't want to make this just like a to and fro the whole time, but so I think there's kind of another shift that takes place that relates back to themes in trade policy, right? So previously, like, you know, when Simon was speaking first, the solution to the global problems is a large distributed, you know, market with lots of competition, lots of distributors and lots of suppliers, and that's the way forward towards global social welfare, right? But then if you're enforcing the patents, and if the ideal world is a world in which, you know, for instance, you didn't have compulsory licenses, because those flexibilities actually already exist, that basically what's happening is we're just clarifying that. But the kind of arguments that were being made, which is suggest, and it has an economic pedigree, right? That which is more efficient, competition or monopoly? So in some markets, you might think monopoly is more efficient, that you need to have, you know, a large firm with economies of scale producing in one place, keeping all that knowledge and technology and using it in the most efficient way, which the incentives of having that market for oneself may contribute. But that's a different vision than the first vision, right? When we were talking about kind of global trade in goods, it wasn't a monopoly is the most efficient way. The theory was a distributed market is the most efficient way. And then when we get into the intellectual property debate, that one shifts. And then people like me start arguing about that competition and distributed markets are the most efficient way. But I think that, and I'll just point out one concession, which I think that it sounds like, you know, we agree upon, which is that the impact of lowering IP barriers won't be felt, you know, for 6 or 7 or 8 months or even a year. But to me, that's okay. That still puts it on the positive side of the ledger, that it will still be better in a year or 2 years or even 5 years. We're going to be taking COVID boosters, everybody around the world, for a long time. And part of that is because we didn't snuff this thing out in the beginning. And so as we look at that future, my vision of a positive future still has a lot of distributed manufacturing and different regional hubs creating those supply, not monopolized in a small number of northern countries. Both to allow those firms to get up to speed. We've already paid for this innovation. Why not make it a public good? Let's everybody get into the innovation game. Let's let the Indian firms try their best. Let's have a big race, you know? And I think that's basically the vision. Let's have more races to the end instead of picking the winner now and letting that winner, you know, keep going. But it's two different visions, and one's not. At this point, empirically, I don't think you can prove, I will concede that you can't prove one of those visions right or wrong, but I'm willing to kind of have that race. And I think you know, Pfizer and Moderna may win the race, but I think the race itself will be better for all.
Henning, I would like to pass the word to you. Maybe can I add the question I had to you also, because I think it's important in this context, just to maybe make clear to the audience the fact, well, first, Anthony made the difference also in the beginning of his session this morning and now in the panel between the TRIPS waiver and then the IP waiver or the patent waiver we are discussing. So can you tell us a little bit about the non-coordination of countries on the IP rights across themselves? What's happening after your comments? So can I add that?
Sure. So I mean, I just wanted to make one brief remark along the debates we just had before. I think it may very well be that when it comes to delivering vaccines for 70% of the adult world population, that the ones who currently manufacture this are going to be the most efficient and fastest to actually deliver this. But I think in addition to that, there's a question which always is implicated in intellectual property, and that is the question as to whether these rights manifest long-term technological advances certain countries have had and industries in certain countries have had over other countries. And if you look at it in a long historical perspective, you will of course note that those countries who now enjoy these benefits, and that those countries whose industries are now on the cutting edge, have in the past used intellectual property as a policy lever in order to ensure that their own industries get to where they are. And they have not used it necessarily in a way where they always facilitate stronger protections, but instead, for example, have purposely avoided protection. Switzerland is a very good example. Switzerland did not protect pharmaceutical products by patents until it was forced by Germany in the beginning of the 20th century to do so. And there's arguments by economic historians to say that the rise of the Swiss chemical and pharmaceutical industry was because of the absence and lack of patent protection initially. Of course, once the industry developed, then IP protection was tailored to fit the current state of the industry. And Germany by no means was actually any different. The phrase "made in Germany," which I don't know if anyone remembers that, because it's probably more like from the pre-global production chains, 1980s, 1990s, hallmark of German quality production. That phrase comes from an old English law which would prohibit German companies to import goods into the UK without labeling them as cheap German imports made in Germany, because at the time Germany was copying from the English, who was the leader of the Industrial Revolution at the time. So leaving aside these particular historical points, what I wanted to more broadly, and that goes to the question, Renata, you were just raising, what I wanted to more broadly say is that if we look at intellectual property protection over the period of the last 150 or so years, when from about the 1880s onwards, we have international mechanisms protecting right holders abroad. And those are there because prior to that, as I just indicated by examples, countries have used intellectual property policy, i.e. the absence or discriminatory grant or maybe full grant of protection, in order to serve domestic industrial policy needs and other domestic needs, technology transfer and so on and so forth. So that's what countries have done. And then IP owners and IP owning industries have come together and tried to push for at least some degree of protection abroad. And they were successful in doing so in the Paris Convention and in the Berne Convention when it came to copyright. So over time, we have harmonized and coordinated protection. And in the course of doing so, we have left for the individual countries to decide how they would want to deal with certain limits to intellectual property rights. In the sense that, yes, we have, especially with TRIPS and onwards, created certain boundaries for what kind of limits are possible. And Tony probably spoke about compulsory licensing and limits to compulsory licensing. And then there are rules about exceptions. Maybe Tony also spoke about the 3-step test under Article 13 for copyright in the TRIPS agreement, or 30 for patents and so on. So we have set certain boundaries as to what countries can do in terms of limits, but what actually the limits are, that is essentially a question of domestic policy. And so we have coordinated protection, but left limits essentially to domestic policy. And if we have global concerns like COVID or climate change or loss of biodiversity, where certain questions about access to IP protected technology and coordinated access become an issue, then the system fails because it has failed to coordinate limits to intellectual property protection. Or, well, put it that way, the question may be the extent to which we do need coordinated limits to intellectual property protection. And the AIDS debates from the 1990s is a very good example again, because in that context, we have realized that a huge range of countries were not able to utilize flexibilities on the compulsory licensing because they lack domestic manufacturing capacity, as we have now. And then we have created a system under TRIPS, maybe Tony spoke about that as well, which allows a bilateral approach where one country can produce for the other country. But we don't have a multilateral approach in that sense. So I think the broader question is whether, and I don't have an answer to that, it's probably also, again, an empirical question, but whether we might not want to think about more coordination in terms of access, i.e. coordinating limits to intellectual property protection. Let me just give one example where that has so far occurred, and it would be interesting to look at how far the implementation of this example has led to actually sort of serving the relevant public good. And this is in relation to copyright rather, and it's in relation to books and other copyrighted works which are made available in formats accessible for persons with visual disabilities or blind people. Now, the background to this is that in all countries or in lots of countries, there are domestically limits which would allow to make copyrighted formats available to those with visual disabilities or blind people. But because these limits are different in terms of conditions and so on, they're not coordinated. And you cannot achieve a coordinated cross-border trade in goods and services which would allow people to access these books, for example, because you haven't coordinated these limitations. So the WIPO Marrakesh Treaty on access to or on exceptions on copyright for visually impaired persons is an example where initial steps have been taken in that direction. And there are further discussions in WIPO, the Standing Committee on Copyright and Related Rights, on this particular issue. Of course, that in itself doesn't ensure production, right? So we still have to deal with trade implications. We still have to deal with sufficient technology transfer, trade secrets in particular. But I think there has been historically, or at least since TRIPS, the more we have an integrated global market, the more we also need to think about coordinating limitations. The European Union is a good example because they've started to do this. They've understood this. So I'll stop there and I'll be happy to discuss this further.
Simon, would you like to comment?
Yes, I would. I mean, I'd like to, let's step back. I think Sean's last comment was very helpful in stepping back and reflecting on this. So we all understand that at least as far as the economics of intellectual property rights is concerned, we are talking about a trade-off between the apparent rewards for innovation and monopoly power. So nothing I'm going to say negates that. But it does mean that in each case, we have a sort of case-by-case assessment of what's the optimal degree of protection. Sean framed it in terms of a race between two different models, a distributed production model and a more concentrated production model. I would argue that we have that race already going on now, because the mRNA vaccines are produced very much in a concentrated manner, where production is located in a small number of places and exported abroad. And as of the end of last week, 850 million doses had been produced under that model. And then AstraZeneca has a distributed production model, where my understanding is that they have distributed production in 25 different locations in 15 different countries, including the Serum Institute in India, which I mentioned earlier. And as of the end of last week, they had produced 570 million. Now, those numbers may change over time and we should track, but I would submit actually we have that race happening now. And it would be very interesting to see, at the end of this year, which of these two models has served us well. And as you say, it is an empirical question.
The problem is nobody wants the AstraZeneca vaccine, though, right? It's like a race between the one that everybody wants and the one that nobody wants. AstraZeneca would be making it started out as it was going to be that race, right? So AstraZeneca started out with Oxford coming in and saying they wanted to open license it. And unfortunately, they were convinced not to, but they did license it out more. And I think they probably would have been ahead if it didn't get so much bad press and, frankly, is a less effective vaccine. So if it was just as effective as Pfizer's vaccine, we would have had a real race. And I think probably AstraZeneca would be winning it right now, but I think it's an unfair race. Now, what everybody wants is the mRNA. You know, those are the ones that are the most effective. So that kind of becomes the question: is it okay to have the race between a really good drug and an okay drug, you know, and make the race that way?
Thank you. I'm going to jump to the questions from the participants, otherwise we won't have time to answer them. So Anthony, there is one for you from your session actually that I think you'd like to address, from Jonathan dos Santos. Are there any ongoing discussion on the interplay between IP and trade in regards to other societal values and interests mentioned in WTO rules, such as environmental protection, consumer safety, etc.?
I'm afraid it's another secretariat. It depends kind of answer. There's certainly no specific in the WTO. There's no specific norm setting discussions, let alone negotiations. But there's a lot of discussion about the relationship between all the IP system broadly and innovation in areas of policy concern, such as climate change, such as the environment, and broader issues such as gender, development generally. But these are more in the character of getting a better sense of how domestic policies have been developed and used effectively or not effectively to advance these broader social goals. One of the the constant refrains generally about the IP system is that it's in effect technology neutral. Public health pharmaceuticals is a glaring exception to that for good reasons, but generally, so it's more a question of how it fits in with a wider range of innovation and technology diffusion strategies, whether government-led or market-led, but fits in with those to promote these broader questions. In our work in what's called the TRIPS Council, the committee that deals with TRIPS, there's been some very good discussions about the interplay between intellectual property system and the public interest, the link with competition policy, and a wide range of areas of where innovation and development of new technologies meshes with those social goals you mentioned. And I've personally found them quite useful, because that actually is governments talking on the record about very specific measures they've taken, policies they've undertaken, but it is at the level of information sharing, sort of a clearinghouse of practical experience, rather than anything that it's about norm setting. And finally, I would mention that, of course, in the TRIPS disputes, there's generally been a broader public policy question behind the dispute, and so some of the dispute settlement work has had to wrestle with some of these broader issues, but in a way only tangentially, not as a pivotal question. So I hope I've usefully avoided the question while sounding informative. So.
Thank you. Henning, would you like to comment?
I have another more general comment on the sort of practical implementation of the Viva, but if you have questions from the audience, please go ahead with those.
Okay, let's keep going, but please feel free to make comments. There is another one actually from Maria Fernanda, also from, I think you started to answer that, Anthony, before, about the opposition between India and South Africa to the TRIPS agreement altogether. It was a surprise for member states on the TRIPS waiver proposal that they submitted a joint proposal.
I'm sorry, I missed some of that. So that question about the India and South Africa as the original proponents of the waiver.
Historically, India and South Africa have opposition to the TRIPS agreement altogether. It was a surprise for member states on the TRIPS waiver proposal.
Well, again, the DVS Secretariat, I really can't speak on behalf of the members, but I think it's fair to say, and well, South Africa and India have both said, even in the context of this debate, that very clearly we're not against the IP system, we're not against the TRIPS agreement, we recognise the significance of incentives for innovation, and they've been careful. I think it's fair to say, careful to say, look, this is a distinct challenge. It's not intended to overthrow the IP system or undercut TRIPS, but rather, I'm paraphrasing, but we want to see a wider range of flexibility in the relatively short term, precisely to deal with the pandemic and nothing else. So that's the position at the moment. I mean, historically, if you go back a long way, I mean, yeah, India was not happy about in the 80s, in the year ago round, about the idea of a TRIPS agreement. However, India was an active negotiator, and some of the important public policy safeguards hardwired into the TRIPS agreement are a consequence of India and other developing countries consciously building them in, and we see them, in a sense, bearing fruit today. That was the essence of my talk earlier, talking about the recognition that the IP system is not there for its own sake, but is there as a public policy tool, is there to promote social and economic welfare, balance of rights and obligations, all of that. That's language from a joint developing country proposal in the TRIPS negotiations. And I would it's a free copy, so I'm allowed to, free volume, I'm allowed to plug it. If you go to the book that Jayashree Wattal, who was an Indian negotiator, and I edited a few years back, that it collects the experiences of the TRIPS negotiators, and you will see that there was an echo similar today, actually, a common resolve to articulate what amounts to good policy, and not simply just a zero-sum trade-off, just a difference about exactly how to capture those ideas of good policy. That's really what defined the last stage of the negotiations. And India was very active there and working with the US and Canada, actually, on exactly framing the compulsory licensing provisions that are so important now. So I wouldn't present things in those stark terms, this may be more a historic echo from the political economy pre-1989 even. It is a more complex and diverse scene today, and I've passed on some of the clear messages of the proponents of the waiver have been articulating even in the last few days. So I think whatever you think of it, for it, against it, or indifferent, it has been presented as a very specific response to an exceptional situation. Whether it's the right response and whether it's going to work and so on, these are other questions. But the way it's been framed and presented is clearly in those terms.
Excellent, thank you. So I just saw you answered one question that I think other people are going to benefit from your answer. Which institution would be more effective in distributing the vaccines and ensuring equitable distribution, the WTO or the WHO? Would you like to answer that live?
I'm talking mainly to lawyers, aren't I? I mean, if you wake up in the morning feeling really lousy with flu-like symptoms, do you call a trade lawyer? I mean, you go to the doctor. So no, I think that's very, very clear. The WHO rightly takes the lead, but there's a number of related initiatives like COVAX. We're partners there, but it'd be crazy if you put us in charge of it, because it is about people who really know about public health, epidemiology, and what it means to construct and deliver a vaccine. And the health systems, if you like, the infrastructure that deliver this stuff, that's critically important. And so our role, of course, is ancillary. There are significant trade barriers that are interfering with global supply chains with the access to inputs. I mean, Simon's commented on this, and it may not be a fundamental problem at the moment, but it is clearly a factor. So yeah, we can contribute there, but it'd be crazy to put us in charge of vaccine production or vaccine distribution. We can barely do it in the four walls of this building. So, but one other consideration, of course, is partnership is absolutely embedded in the way all of these organizations are now working. So our Director General met with with Dr. Tedros, WHO DG, with Darren Tang, WIPO's DG, just 2 weeks ago, and they said, look, yeah, we have to, and this kind of political leadership can be very helpful at our level. They said, look, you've got to work together. You have to work with individual countries to help them identify and overcome any problems they encounter, and that's where we pitch in. So it's not a saying, well, look, it's either them or us or whatever. WHO takes the lead, rightly so, working with other initiatives, COVAX in particular, and we help out. We provide our specific chunks of expertise where they're needed.
Thank you.
Tony, what would you say is the WHO's kind of most powerful tool, right? I mean, like the WTO's most powerful tool is probably dispute resolution, or maybe the treaty making authority. It's an effective treaty making body. It's an effective dispute resolution body. It's an effective trade lawyer. But what would you say the WHO's most effective tool is? Maybe expertise, or does it have a different tool?
Yeah, I mean, I work with them a lot, and just it's after 6 o'clock here, so I'm speaking personally. I've been really dismayed at some of the criticism, because I know that there's some fantastic expertise and the most moral international civil servants you would ever encounter, who are working themselves inside out particularly on this matter. So certainly expertise and really the integrity of the experts working on these issues, and their collegiality and willingness to cooperate across the system. In addition, I mean, it's a much bigger organization than that. We have just one office. They have regional representatives, national representatives. They have the regional organizations, the related organizations, regional organizations. So they have really good understanding of the situation on the ground across the globe, and they have really good working relations at a functional level in many systems, and they are on the ground getting their hands dirty on helping out on these issues. So if there are issues, I suppose it's difficult coordinating such an enormous exercise at a critical time. But it's both the expertise and the breadth and embeddedness, if you like, of that expertise across the globe.
Excellent. May I take 5 minutes more of your time? Is it okay? So we can address the 2 final questions. I'm going to read both together. I think, well, there is a third one coming, but I think I'm gonna leave.
Henning, did you want to say something? I just said there was a hand up to this
Just on the second question, but Renata, go ahead. If you present the questions, I'm happy to take at least aspect of Carolina's question.
I was going to ask for you to lead this one. So Carolina asked that in some countries there is a debate about the possibility of changing internal legislation to approve a temporary patent waiver for the vaccines. How do you see local initiatives like that, and how it could impact the multilateral discussions? And based on what Simon just said, comment about the distribution of the vaccines in case of a country like Brazil, for example, approves it. Henning?
Yeah, so just briefly, because I'm sure others might also have something useful to say on that. So as I think Tony has made clear, the TRIPS waiver in itself, of course, doesn't do anything to the domestic patent regime. You have to implement in the domestic legislations, be it patent, test data exclusivity, copyright, industrial design protection. There you have to implement whatever is necessary from your own perspective, and of course within the limits of what any sort of waiver would allow, and to ensure that that leads to changes on the ground. And I'm not going to specifically comment on what exactly that might have to be, but I wanted to just add one further complexity to this whole debate, because clearly TRIPS is not the only international IP agreement. There's many other agreements specifically on intellectual property. Then there are a huge range of agreements which implicate intellectual property protection, like investment protection agreements. Then there's domestic constitutional protection, plus perhaps human rights protection for property, often including intellectual property. So what that basically shows in a nutshell is that we have created a global mechanism or mechanisms which effectively only allow us to do where we can identify a common denominator of policy space and act in accordance with that. Or alternatively, if we were to implement some sort of a waiver, we would in the waiver want to ensure language which could be understood as to possibly also cover agreement of the relevant countries concerned to temporarily at least waive these other overlapping obligations. So I think it depends, first of all, what you do on the multilateral level, not only in TRIPS, but in other areas. And then, of course, essentially based on what is possible, you can act domestically. And whether that then has any implications for distribution, well, of course, IP rights are territorial rights. So what you do in your country matters for what you can do locally. But if we have these global questions of access, again, it's the point of coordinating that. And that's, of course, where we might want to have a coordinated, harmonized approach, as I suggested earlier, in terms of dealing with any sort of possible limits to intellectual property rights in a coordinated fashion. I'll leave it at that because I'm sure others might want to say something on that as well. Thanks.
Sure.
So just to go back, because this is a super sticky question, but it's great for the trade students of, what would the waiver do vis-a-vis the permissions to use compulsory licenses, et cetera, that are available right now? So, what would be the legal effect of the TRIPS waiver? So one of them, I don't know how deeply you all have gotten into Article 31, which is of TRIPS, which is what authorizes compulsory licenses. But a key provision in that is, and I believe it's 31F, which says a compulsory license, although permitted, must be restrained to largely the domestic market. So, we tend to interpret that as, something like 51%. So you can't export more than 51%. And that raises a problem, because then a country like Brazil that potentially has enough capacity to make a lot more vaccines than just its own country can't really ramp up exportation or ramp up production to export to many, many other countries. So if the TRIPS waiver went into effect, one of the effects would be to lift that requirement. So although it can give a compulsory license now, under the new regime, if we had the TRIPS waiver, you could give a compulsory license with unlimited exports. So you could make as many as you possibly could and export them abroad without restriction. And so that's actually a very important potential benefit vis-a-vis where we are right now.
We have two questions, and I know that two of you at least have to leave in the next 5 minutes. Maybe Renata, you can combine the questions, or
I was going to suggest that, because I think they can
or you can ask them both and see who wants to answer. Mm-hmm.
The first one is more general from Yamanula. He's saying that, as we all know, with the onset of the coronavirus, one group benefits in their business, for example, all online stores, Amazon, Alibaba, etc., and another group that were hit and lost in their business. What do you think about what the governments should do to those who got harmed in their business? and what should be done for those who have been harmed in this situation to get back on their feet? Or how long would it take to get back on their feet and run their business? I think that's a hard question to answer, but I'll leave it there. And the last one is from Karina. Since the beginning of coronavirus pandemic, we have seen several disruptions to international trade on medical devices and vaccines, like India restricting vaccines exports, US restricting exports of raw materials, EU COVID-19 vaccines, export authorization scheme, CARES to masks. What can be the solution? Who has the answer to that? Simon?
Simon.
So with respect to the first question, I think how I would answer it, it turns critically on how the losing companies were harmed, because it's unclear from the question whether the implication is that the winning companies have harmed the losing companies in an anti-competitive manner, or whether we're talking about a generalized reaction to either the demand collapse or public policy. So I think that's another "it depends" answer to, I think, a very difficult question. With respect to the second question, as I indicated earlier, I think I would be in favor of more restrictive obligations on export curbs and controls in a WTO agreement. But as I also indicated earlier, I don't think they're particularly judiciable in any time frame that makes any sense. So then the value of those WTO obligations would be hopefully to shift the debate in the country which has imposed the curbs, where we would have to argue that these curbs are counterproductive, or maybe because they disrupt supply chains, or on some other ground. So this may well be one of the cases where law is useful, not from an enforcement point of view, but as defining a point of reference for good behavior, which one could then use in a debate about, internal debate about the value of withdrawing the export curb in a crisis. Thank you, by the way, for the opportunity to participate.
Excellent. I think we need to wrap up because our speakers need to leave. This was fascinating. I love the discussion. Thank you so much. Padide?
I just would like to thank again our panelists. I want to thank Tony for giving us our whole morning, for his whole afternoon and evening, and joining us today. This session will be available on our YouTube channel. There is also a session tomorrow morning on plurilaterals that I hope you all will join, and regional approaches to trade, and a talk by former DDG Alan Wolf at 10:30 tomorrow, followed by another panel on the World Economic Order, new challenges and opportunities. I hope you will all join us. Simon, Henning, Sean, and Anthony, thank you so much for joining us today. We'll see you all tomorrow. Thank you again.
Fabulous agenda.
Enjoyed it.
Congrats,
Bye.
Great panel.
Yeah.
Thank you.